think at my wedding, I think it was.
Right. Always, right?
I assume you want to be out of it. I don't want to. It's always smaller than I remember. Well, I mean, not the room, but the amount of
It's capital. It's amazing. It's small Senate.
totally.
You
Yeah.
see my TV doing the State of the Union. My house is so huge, and then you get there, it's so small.
So my first argument before this court was not in this court.
Oh yeah.
To inaugurate the new fourth DC house in Bankroom.
Just recently?
No, wait, I'm sorry, second.
Oh, see, if it's the fourth, they just
No, this
just
is what
opened.
I'm sorry.
Second. Your fourth DC is much bigger. The new one.
I actually haven't been. No, I haven't really been.
It's nice. The new one. They just opened it. Right. I think it's around COVID time. When you put in its judgment.
in session. All in policy, please, draw near. Give attention, it shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen of the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on today's docket is Freed versus the state of Florida. Counsel?
Good morning. May it please the court. Edward Geddes on behalf of the petitioners. With me at counsel table is Jamie Cole. This case presents two fundamental questions for the court. First, whether the Florida Constitution imposes real limitations on the power of the judiciary, or whether the legislature may simply modify those powers when it sees fit. And second, whether representative democracy at the local level is feckless. We respectfully suggest the answer to the first question is that the Florida Constitution imposes unavoidable and inescapable limits on the power of the judiciary. And with respect to the second, that local democracy must be allowed to survive in our cities and our counties, even at the expense of some state legislative frustration. I'll address these two broader questions in the context first of legislative immunity, and secondly, in the governmental function immunity. As a matter of more than 2 centuries of American history and tradition, the judiciary has never had the authority to inquire into the motivations or intentions of individual legislators acting in their legislative capacity. That lies at the heart of legislative immunity. And in fact, this court and the United States Supreme Court have both described this principle as a cornerstone of American democracy. And yet, in this case, the First District's decision endorses the idea that the legislature may expand the constitutionally restricted authority of the judiciary to engage in such an inquiry and hold legislators liable for voting. In Bogan, the Supreme Court unanimously stated, where the officers of a municipal corporation are invested with legislative powers, they are exempt from individual liability for the passage of any ordinance within their authority, and their motives in reference thereto will not be inquired into. If the First District's decision on this point is allowed to stand, if the legislature is allowed to expand or adjust the powers of either of the other branches in order to punish local elected officials, then our 3-branch form of government essentially becomes a single all-powerful branch.
Could I ask you to connect those dots a little bit, because I followed the peroration up until where you said no one can inquire into the motives of these legislators, and then the next sentence is about penalty, not about inquiring into the motives. And as I understand the deliberative privilege, it protects deliberation, not a particular absence of consequence for legislative decision. Can you connect those two dots about why a penalty constitutes an impermissible intrusion into the motives and deliberations of a legislator?
Certainly, Justice Curiel. As Justice Thomas wrote for the U.S. Supreme Court in Bogan in explaining the fundamental necessity for legislative immunity is to preserve the independence of local legislators. Because absent that independence, if with every vote a legislator can be hauled into court and asked, why did you vote the way you voted? What were the facts?
Who's asked that? Where in the statute do we have that inquiry going on? Because I agree that inquiry would be problematic. I'm having a hard time connecting the dots between what the statute says the legislature has given itself the power to seek and that inquiry that you just stated, inquiring into the motives of a legislator. Why is the motive of a legislator relevant?
I agree that it's not relevant, but Section 3C of 790.33 requires that the imposition of a fine of the penalty on an individual local legislator be made after the court makes a determination that the violation was knowing or willful. And I'm not quite certain how an individual fine could ever be imposed for knowing and willful conduct without inquiring into the motivations or processes, legislative processes of an individual legislator.
Don't we do that all the time, though? I mean, motive is not an element in a criminal case, right? All we find is
some do, but
okay. But by and large, if we've established that an actus reus was committed with a mens rea, and it was voluntary, that is generally enough to say that the behavior was culpable. I'm not sure. I credit the answer that you've given because it does sort of start to connect the dots. But then the problem is, you know, I don't know that the legislature has contemplated here a freewheeling inquiry into the motivations of the legislators. It has instead just prescribed a penalty for certain acts. And if I'm inclined to agree with you that probing into the motivations and the internal thought processes of the legislature is constitutionally problematic for the separation of powers, I'm not sure how that carries the day. I'm not sure why that's the basket you're putting your eggs into.
Well, in this particular, the legislature chose the language it chose. When it created this remedy or penalty, it chose to include some intent component into this. Conceivably, the legislature had simply said, if there's a preemption, any local legislator who voted in favor automatically gets fined.
Well, what about this? And this is, of course, a matter that the parties have briefed extensively, but I'm curious as you know, let's say they cut it all the way down. All county governments are hereby preempted. There shall be no county government, or rather there will be 60 county governments instead of 67. You would agree that the Constitution doesn't stop that, right? And that's not an infringement on the deliberative process of any legislator, right?
If and when the legislature chooses to abolish any particular local government, then obviously the court's going to address the consequences of having done so.
Well, yeah,
but as long as they haven't.
What I'm struggling with is the consequences for your argument, right? Your argument is that it is an infringement on these legislative prerogatives securing the separation of powers that the legislature not adopt these penalties. And what I'm saying to you is, if you concede that the ultimate penalty, abolishment of the local government, would not require an inquiry into the motives of anyone and is constitutionally permissible, isn't that a real problem for your argument?
I don't think so, Your Honor, because it creates two different problems, admittedly. The abolishment of a particular local government creates its own set of problems. But if you're going to have a local form of government where the citizens of Florida vote with the expectation that their vote has some democratic consequence because they are electing individuals to represent their interests, and the Florida Constitution confers on those individuals legislative power to perform their duties, then to pull the rug out, so to speak, from those local legislators by saying, well, you can do that, but if you do that and we don't agree with you, or if you take a position that we've determined is not a permissible one, then we're going to punish you individually just for how you voted. And in a completely different way, that undermines democracy.
Well, but our Constitution says that with respect to municipalities, that the municipalities may exercise any power for municipal purposes except as otherwise provided by law.
Correct, Your Honor.
I mean, and our cases are very clear about the superiority of legislative power in this arena. Am I wrong about that?
You are not wrong, Chief Justice Kennedy.
And so that's why this whole case is kind of mystifying to me, because underlying what the legislature has done is this express constitutional provision.
We have never disputed.
Well, it would be hard to dispute it.
Well, and we have never disputed it, Your Honor, that the legislature has the ultimate ability to preempt a substantive area of the law. But it goes farther than that in this instance, because obviously the legislature isn't saying simply don't legislate in this field. Don't legislate with respect to firearms and ammunition because we've preempted it and you can't enact that. We get that. But then what happens is, in a scenario such as this statute, where in fact Section 790.33 opens the door to local legislators to legislate in certain areas relating to firearms, and then it says, well, if you do so, and by the way, you didn't do it right, elected official, we're going to punish you. We're going to punish you with a fine that targets you individually, that takes away your ability to have your defense paid for by the local government, that exposes you, and essentially says, don't you dare vote. Even though the statute says you may, and the Constitution says you may, don't you dare vote. And historically, Your Honor, as you know, this issue comes up many, many times. The remedy for a preempted ordinance is a legal action to declare it preempted, unconstitutional, and unenforceable. But this goes a step further. And it says if you voted knowingly or willfully, whatever that may mean, then there are additional consequences to mere preemption. There are punishments. And that's where I think the problem transgresses. No question. There is no question. Underlying all of this is the notion of the preeminence of the state legislature to preempt substantive areas of law. We don't dispute that. But this is a legislative fire hose to put out a birthday candle.
But aren't we talking about here the legislature's ability to change substantive law?
Correct. And
I mean, that's completely vested in the legislature.
And they have, and they've changed the substantive law.
And a governmental immunity or legislative immunity, whichever, is a substantive law issue, correct?
I don't believe so. Legislative immunity.
It derives from the common law. The immunities that you've cited derive from the common law.
The legislative immunity historically has derived from the common law. But in the state of Florida, it is also tethered to the Constitution by virtue of the conference of legislative powers on
but as the
county
case law says, the Constitution confers the legislative power in the state legislature. It's very clear in our case to say that. Right,
but they coexist. You don't, I mean, the legislature doesn't get to ignore one to achieve another one, to comply with another one. You can't just suddenly say you're going to be a legislator, a local legislator, but you're not going to have any, but you can't legislate, or you have no immunities for engaging in legislation. That's where the problem lies. If I'm trying to hypothesize a scenario where it's not problematic, but the idea that you can have constitutional authority to legislate and not be protected by legislative immunity is contrary, it's certainly contrary to Bogan. That's what the U.S. Supreme Court said in Bogan. If you've got that power, then you have legislative immunity. So if the legislature wants to undo that and have greater control over legislators at the local level, well, they can go through the process of amending the Constitution. They can take away that provision of the Constitution that says that you have legislative powers and put it in a statute over which they have plenary control.
Which provision are you talking about? Exactly.
Article 8, Sections 1 and 2, that give express legislative powers to local legislators. Now, that's a structure, and this is what the trial court originally concluded, that that constitutional structure is beyond the power of the legislature to change through a statute. There may be other mechanisms, but through a statute, they can't alter it.
Article 8, Section what?
Article 8, Section 1, which deals with counties, and Article 8, Section 2, which deals with municipalities.
The only section in Article 8 that I see that specifically addresses this is in Section 5B, where it says each county shall have the authority to require a criminal history records check and a 3 to 5 day waiting period.
As to gun-related issues, yes. I'm speaking more broadly as to the structure of county government and the structure of municipal government.
That specific issue, the trial court held that it was no problem, had no problem with a conflict with the statute, and held
Correct.
it to be valid, and there was, this appeal relates to that specific provision, not at all, right?
Correct, because that's the trial court correctly concluded. It's in the Constitution. The state didn't dispute that issue, didn't appeal that, any ruling on that. So that's not here. That's not before this court.
Okay.
Well, I see I have 4 minutes. Let me turn briefly to governmental function immunity. For decades, this court has recognized that local governments enjoy immunity from liability for certain decisions that constitute fundamental discretionary functions of governance at the local level. And in fact, the state has conceded, has acknowledged that that immunity is a non-waivable one. And that was the court's ruling in Commercial Carrier, that notwithstanding 768-28, which doesn't address this, there were certain fundamental governance decisions that were beyond the scope of the judiciary to review. And there is no more quintessential discretionary function than the enactment of legislation. And the statute itself imposes under Section 3F liability for the mere promulgation of legislation.
Doesn't that argument prove too much? Because what you've said just now is that there's no more central function than the passage of legislation. Okay. The passage of any legislation? Or, I mean, isn't the narrower question posed by this case the passage of legislation in a field that the legislature has purported expressly to occupy? Like, that doesn't seem to be a core function. I would agree with you that a core function of my municipal government is to pass zoning ordinances or hygiene ordinances or speeding or whatever. Those are things that I think commonly people expect their municipalities to do. How is it a core municipal function to occupy a field that the state has expressly stated that it means to preempt? How is that a core city function?
Okay. There are two components to the answer to your question, Justice Carrillo. The first one turns on the four-part commercial carrier test, the four-prong test. And the fourth prong, which is the only prong that the parties are in disagreement about, is the question of whether or not the act or omission or decision in question is within the authority of the individual or entity that made it or took the action. And the state posits that the question should be asked in terms that assumes the answer, which is, in other words, do you have the authority to enact an ordinance that's preempted? If you ask the question that way, the answer will always be no. If you presuppose the negative into the question, it becomes a meaningless test. And in fact, if you look at the history of this court and how it has applied that four-part test and the fourth prong, it has elevated the question to a much higher level. In other words, do local governments have the authority to enact ordinances, to enact legislation? And the state concedes, obviously they do. So we can't really abide by the four-part test in commercial carrier and ask the question the way you've suggested, Your Honor. That's because it assumes the answer. It assumes the answer.
Well, okay, so let's try not assuming the answer. The city of Coral Gables, where I live, or the city of Key Largo, decides that it's going to pass a local ordinance funding military aid to Ukraine. And the federal government says, that's kind of outside your scope, Coral Gables, Key Largo. Thanks, but you have no power to appropriate. I haven't presupposed an answer, but what I'm trying to get an answer to is that's not a core municipal function. And we're able to discern that it's not a core municipal function because of the subject matter of the law, right?
Let me see if I can narrow it. First of all, with respect to the example that you gave of the federal government, frankly, doesn't care about the dynamics of local government. So pick another preempted state issue, anyone you want. I'm going to proffer an example.
Go ahead.
790.33 specifically creates an exemption that allows a local government to enact zoning ordinances. All right? Let's assume Coral Gables, to pick your hometown, enacts an ordinance that says there shall be no gun sales, no gun shops, there'll be no gun ranges, there'll be nothing within 500 feet of a school. And along with gun sales, they also have, there will be no liquor sales, they will have, there are a number of other businesses that are excluded from within that zone. All right? It's specifically contemplated that the local government can legislate in that field. It is, by virtue of that fact, it is a discretionary decision to decide to enact that legislation. But if that ordinance is enacted and somebody challenges the ordinance and it is subsequently found to be preempted because somehow there's evidence that the design or purpose of the ordinance was to restrict sales or interfere with gun ownership or something like that, then it's automatic. You're automatically exposed to damages for a wholly discretionary function.
I'll let you keep going.
And I apologize, Your Honor. I've gone over my time.
You have exhausted all your time.
I have.
I will nonetheless afford you 4 minutes for rebuttal.
I actually exhausted my 20, not just the 16. I apologize, Your Honor. Thank you.
Mr. Chief Justice, and may it please the court, I'll start with legislative immunity, which plaintiffs argue is not a common law defense, but a constitutional rule that bars the legislature from enforcing its preemption statutes by holding local officials accountable, even where they knowingly and willfully enact preempted ordinances. The starting point of this analysis is that unlike Congress, which is a government of enumerated powers, the state legislature has the authority to legislate in any area not prohibited to it, like speech or religion. So it's plaintiff's burden to identify a provision of the Constitution that restricts the legislature's power to adopt penalties like this, and there simply isn't one. Plaintiffs first point to Article 8 of the Constitution for its grant of default home rule powers to local officials, and they couple that with U.S. Supreme Court decisions that emphasize the importance of the immunity for those who exercise legislative power. But plaintiffs have it backward. Their lead case, Bogan versus Scott Harris, holds only that Congress intended in the enactment of Section 1983 to maintain common law immunity. In 790.33, by contrast, the legislature clearly abrogated the immunity by creating penalties for officials who enact a preempted ordinance. And against that backdrop, the fact that Article 8 by default gives local governments some form of legislative power simply puts those officials in the same position as the local officials in Bogan, which is to say they have this common law immunity, but it can be taken away by a higher power, here, the state legislature. And really, to the extent that Article 8 speaks to this issue at all, it does so by establishing a constitutional hierarchy. It says that local officials have only those powers that are not inconsistent with general law, meaning they're subject to the plenary control of the legislature. And with that hierarchy established, there's no reason the legislature wouldn't be able to provide penalties for its statute, just like any other statute. They've also pointed to this court's decision in League of Women Voters, but that case simply recognizes a parallel between the United States Constitution and the Florida Constitution, which is that just as the speech or debate clause clothes members of Congress with immunity for their legislative acts, Article 2, Section 3 of Florida's Constitution clothes members of the Florida legislature for their acts. The case says nothing about local officials, of course, because Article 2, Section 3 requires the separation of powers only between the branches of state government. Now, as I understand Mr. Geddes' argument on this point, it's that Article 2, Section 3 limits each branch only to its assigned powers, and that's of course correct, meaning the judiciary may exercise only powers that are judicial in nature. The problem with the argument is that legislative immunity is not a question of judicial power. It's a traditional defense. Among other things, it's well established that it's waivable. It doesn't go to the court's subject matter jurisdiction. I mean, you can contrast that with the political question doctrine, which I'll get to in a minute. You know, in the Citizens for Strong Schools case, it was outside the scope of the judicial power to determine the adequacy of a particular level of appropriation because that's just a toolkit that the courts don't have. We just don't have the same thing with legislative immunity because determining intent and damages are traditional judicial functions.
How does the knowing and willful provision work in practice? How would it?
Yeah, so Your Honor, we interpret the statute to limit the fines provision at least to just those officials who know the ordinance they enact would be preempted, which we take to mean a substantial degree of certainty that it would be. And turning to discretionary function immunity, this court was clear in Wallace v. Dean that Florida's discretionary function immunity doctrine was just an application of the political question doctrine as applied in common law tort cases. We're not challenging anything about Wallace. The discretionary function framework may well operate properly in common law tort cases. We're simply asking the court to make clear that it doesn't stand in the way of statutory enforcement actions like preemption suits. Whether we call this discretionary function immunity or political question, the key point is that common law tort suits allege unreasonableness and preemption suits like this do not. To illustrate the point, consider a plaintiff who sues in tort because he's injured due to a negligently installed traffic light. This is the stuff of traditional discretionary function immunity. The fact finder can assess negligence without a problem in a case like that because there's a standard of care for how to install a traffic light. But contrast that with an example where there is no traffic light at all, and the allegation is that the state was negligent for not appropriating money to pay for one, right? So in that case, the court would have no standard for an appropriation, right? So that's basically the Citizens for Strong Schools case, right? Now contrast that in turn with 790.33. The preemption provision supplies the judicially manageable standard. The court doesn't have to second guess whether a challenged ordinance is reasonable as a regulation of firearms. It just has to ask whether it is a regulation of firearms. That's just statutory interpretation, which is a basic judicial question, not a political question.
But are you saying that if you had a statute that explicitly purported to waive or to take away any kind of immunity that a local government would have for a discretionary function, that it would be essentially non-justiciable if someone actually sued under that because of the political questions doctrine?
So I take Your Honor's question you're asking. So if we add the word unreasonable to 790.33, so 790.33 now prohibits only the unreasonable regulation of firearms. Yeah, I think we'd have a very different question, because the court is simply no court is going to have a standard against which to assess whether a firearms regulation is reasonable or not. right? That's really exactly the same problem there was in the Citizens for Strong Schools case. But that's, of course, not what we have. All we have is a basic preemption statute that asks the court to engage in statutory interpretation, ask whether the ordinance before it is a regulation of firearms and apply some enumerated exceptions, and this is the stuff of quintessential judicial decision-making. And really, the fact that statutory interpretation is a basic judicial function is exactly why preemption statutes categorically do not present a political question problem. And I don't actually take plaintiffs to contest that. I think their only beef is with the damages remedy. And that fares no better because the assessment of damages is also second nature to the courts. If the court has no questions, I'm happy to rest on our brief.
My friend suggests that courts have always made inquiries into intent and motivation, but respectfully, I don't think courts have ever engaged in examinations of intent or motivation when it comes to legislators. And that's the gist of our Article 2, Section 3 argument as to legislative immunity, which is that if the legislature wants to create a remedy, it can't do so by thrusting the judiciary into a scenario where it is hauling legislators into court and asking them why they voted. Did you know? What did you think was going to happen when you enacted this ordinance? That's where you end up. That's why this particular remedy cannot stand, even if you get past the question of stripping away legislative immunity from constitutionally legislatively authorized bodies.
Well, the notion that in one of these prosecutions that they would be hauled in, but they don't have to testify. The state's got to prove it, right?
I'm not sure how you could ever establish, this is not a criminal penalty, so it's a civil penalty. There's no right of self-incrimination here.
But the burden is still on the plaintiff to prove it, correct?
Correct, and they would get to depose the local elected official and start asking them these questions, and you end up in the exact same place. I don't know how you can avoid that problem. I think that's an inherent defect in this remedy.
It just seems, though, like, sorry to interrupt you, it just seems like at the end of the day, it's just you make a very plausible kind of policy argument, but it just doesn't seem like there's any sort of constitutional foundation for what you're talking about.
Well, I think, first of all, our constitutional foundation, admittedly, is Article 8, Sections 1 and 2, and if the court doesn't believe that legislative immunity is inherent in being conferred legislative power, then obviously...
I mean, it just depends. I mean, I don't know if by that you mean it's kind of a baseline against which the legislature would sort of legislate, but if the legislature consciously chooses to take that away in this context, then, you know, you're left with a policy argument.
Well, no, I'm not, because then we get to the secondary argument of whether or not the legislature can, in the process of providing this remedy, expand the power of the judiciary. Because legislative immunity aside, this court has never countenanced the idea that the judiciary may make these kinds of inquiries of legislators. So I have 1 minute, and I apologize, Justice Muñiz. I do want to tackle a couple of the comments that were made with respect to governmental function immunity. And it brings me back to the example that I offered to Justice Curiel regarding a zoning ordinance. My friend suggests, well, all the court has to do is go in and make a quick determination as to whether or not it's preempted. Not really. Section 790.33, which authorizes the local government to enact a zoning ordinance so long as it is not designed for the purpose of restricting or prohibiting the sale. That is hardly a non-political question. That is the height of entanglement with the judiciary now coming in and saying, well, let's find out whether or not, what was the reason why you were enacting this zoning ordinance? Was it designed to thwart the sale of gun sales, or was it designed to protect children, you know, from having these vendors within 500 feet? It is not It is not the black and white scenario that the state is suggesting. And lastly, with my remaining 2 seconds, the distinction between tort and statutory remedy, I think, was laid to rest by this court in Wallace. Because in Wallace, as it examined the two-part process, when it asked first, is there a duty of care that exists that triggers the governmental function immunity, the court noted that the duty can arise either from the common law or from a statute. And we respectfully suggest that in this case, this statute creates its duty, creates the standard of what is reasonable. Can you enact this ordinance or not? So we respectfully request that the court quash the decision of the First District Court of Appeal and remand for further proceedings. Thank you for your time.
Thank you, counsel. We thank you both for your arguments in this case. The court will now take up Beach Boulevard, LLC versus Live Oak Banking Company. You may proceed, counsel.
Good morning, Your Honors. May it please the court. I'm Richard Timms. I represent 1944 Beach Boulevard, LLC, who's the appellant in this matter. I was last here maybe 35, 36 years ago working as an intern for Justice Parquette. Don't know that I ever saw the inside of this courtroom. They kept us in the library or in the musty basement working on the jurisdictional
Well, welcome
briefs.
back.
Yeah. It's good to see two of my classmates on this panel. We're not here to talk about the musty basement, obviously. We're here to look at an appeal of we're trying to seek determination of whether the appellee's asserted lien on Beach Boulevard's assets is properly perfected as a result of their failure to follow the protocols that are outlined in Section 679.5021 Florida statute when they filed a Ucc One Financing Statement using an abbreviation of my client's name. This case
That was a mistake.
That was a mistake, and I think that is admitted. The 11th Circuit has found this to be an important question for the court to decide, and certainly this is on the speaking tour right now. When you go to the business law section, they're paying attention to it. Before I address the legal issues, I want to make sure that the court understands how this plays out in the real-world context. Whenever a lender makes a loan to a secured by receivables, inventory, other personal property, there are usually three instruments. There's the note that evidences the obligation to pay. There's the security agreement, which is the pledge of the collateral. Sometimes those two can be combined, but those are the two things signed by the debtor. And the third item is a Ucc One Financing Statement, which is it's usually filed by the lender with the appropriate authority just to put the world on notice that somebody's claiming a lien on that asset. Having that document filed properly is important because it establishes lien priority vis-a-vis other creditors, and it also, that's on a first to file, first lien right basis, and having it filed of record also alerts potential prospective purchasers of the debtor's assets that hey, these assets may be encumbered. And so it's very important that the notice of the lien be properly filed and published so that subsequent purchasers and lenders don't find themselves faced with an unknown lien. I mentioned that in Florida, financing statements...
Let me direct you. Would you agree that the outcome of this case hinges on the safe harbor provision, ultimately?
It's all about the safe harbor provision.
And I think maybe the most critical language in there is figuring out what is the standard search logic of the filing office, and that language that says if any. So I think the commercial law amicus initiative framed that well and really focused on that in their amicus brief. And I'm wondering, there was no response to the amicus brief from either party, but it seems like if the search in Florida is viewed as bringing up the whole list, then that wouldn't be a search logic. And the if any has to mean something. So it means that there are electronic systems that will give some result that don't fall under the search logic provision in this context, right?
I take exception to the amicus brief that it says there's no search logic. I think in our A15, our appendix, Florida has adopted the compact name as its search logic. And so there is no definition of search logic in the statute, but what we have is a procedure. The financing statement is only effective if it identifies the name of the debtor. It has the name of the debtor, has the lender, and the collateral. The name of the debtor is only sufficient if you use the organic name filed of the entity as filed with the Secretary of State. You then put that in. If you follow those procedures, I promise you, that lien will show up if a searcher uses that same protocol and searches under that name. It shows up. And the intent of
when you say it shows up, you're saying it will show up in the search at the top of the first page that's displayed. Is that what you mean?
The liens of, yes, the 20 page.
Right. I mean, it may extend beyond the first page because of the number of financing statements that may have been filed.
Right. And if you understand the briefs, the whole goal of putting this system in place was to shift the burden and get rid of all these decisions on how far back you got to go, how far forward you got to go, what variations of the name should you search under. All of those items that just led to all kinds of crazy results. Most of the time, those results were, based on the judge's opinion of equity.
But I'm sorry to interrupt you, but I think that this gets to the heart of what Justice Lawson is asking about, which is, so the first point is the term in the statute, the court has to give that meaning. The agency can't just say whatever we call is a search logic is a search logic. They couldn't just hand you, they couldn't just say our search logic is to print out our entire list and hand it to you and we can assure you that you will find your thing in here, right? And so I think his point is that by having a quote unquote search logic that doesn't really winnow the results, that essentially you're right back in the same spot of where all this discretion of, do you have to go a page back, do you have to go a page forward, et cetera, et cetera. And so really, I mean, I think the amicus brief makes a compelling point that essentially we're dead on arrival because in Florida, notwithstanding what the agency says, and I know, constitutionally we don't have to defer to them if they, have an unreasonable sort of interpretation of the statute. And so really there is effectively no safe harbor here.
Which means that you have to put in the exact name. You have to use
that wouldn't bother you.
That wouldn't.
To me, I think that's a red herring, honestly. I mean, why?
Well, it's not a red. I mean, I think the result isn't so much that you have to put in the exact name, is that you have to get it right when you file the thing, and if you didn't, then it's basically a strict liability sort of, no margin for error kind of situation. And if Florida wants to have a real search logic that does winnow the search, then the safe harbor would kick into existence.
Well, I would say this: there's only one person that can control what's input, and that's the lender, and that's what the legislature intended to do. And the drafters of UCC, let's put the risk of a misfiling on one person. And my point is, why have a statutory safe harbor if the courts are going to ignore it? Why have it? And I don't think.
Well, but it has to. The conditions for it have to exist, and the condition of a standard search logic is part of the requirement, right?
It's not a defined term. So
I understand that. I understand that.
To me,
and I understand that there can be differences of opinion about it, but the amicus brief I think makes some compelling points about how this operates. Because if I understand correctly, there's a hypothetical on page 25 of the amicus brief, where if I'm understanding. If it doesn't show up on the first page, okay, that it is produced by this search, then it's not going to be considered perfected, right?
That's it. It's unless you're right. Yes, absolutely.
Well,
under the safe harbor.
Unless, of course, you get to the end of the first page. And you have, and then you have the name is correct, and then it goes on to the next page.
Yeah.
Okay. But the problem with saying if it's not on that page, then it's not perfected, is that can change. Something could be not perfected, and then become perfected because of financing statements expiring and going off. Am I wrong about that?
No, I think the.
Am I wrong about that?
No, you're not. But I don't.
Because that's the hypothetical, and that seems to me to create kind of a very anomalous situation.
Well, the amicus does a great job of pointing out, criticizing the system, but I don't think that's necessary because, to your point, get back to where we start. Who bears the risk of filing it correctly?
This argument does not hurt you.
I know, but you can have.
So it's not. I understand about who bears the risk, and that this is like ultimately they got to get the name right.
They get it right, and they follow what the statute lays out. This system implements it. No, it's not a Google search with algorithms that are predictive of what other variations may exist. I don't think there's any requirement of that. That would actually shift the risk to the programmer to make sure that he's got all variations thought through. But
doesn't the subsection, the safe harbor provision, contemplates that there may not be a standard search logic? Because it says, if any. So the legislature says, okay, if it's here, then this is what happens.
Yes,
but that implies that if it's not here, and it may not be, even though there's a computer search, there may not be a logic, then that provision just doesn't help the other side.
And that's the point here, is that the legislator wanted to get away from this, all the variations, all the problems with search engines, all that. Just said this is the simple, hard, fast rules. And when a judge in this instance says, well, they're only one page behind, maybe that's just kind of inequitable, is what's basically happened. He's taken away the safe harbor. He's ignoring it. And he's injecting the very same uncertainty that the legislature and the UCC drafters intended to get around. Our search engine in Florida will evolve over time, I'm sure, as computers get better. But right now, this is what we have, and it works. It works. And it implements the legislative intent. You follow these rules, and by the way, there's no safe harbor for a searcher. If they input the wrong name, they're out of luck. So this safe harbor appropriately balances those risks on both sides, because there's only one person that controls it. I keep coming back to that point, and I think in this case, what's happened is that they have they're injecting the same uncertainty. I don't have any qualms with our system here, but now to start attacking the methodology, getting into algorithms and that consideration of all those type of things, when we do have something.
But you haven't answered my question, I don't think, about how something can be on one day not perfected and on another day perfected.
That's luck, but it's all.
Oh, okay, it's just luck. It's going to depend on luck. That's quite a system.
No, I say no. You're perfected if you follow the protocols. But under the safe
again,
harbor,
talking about this example, if you're looking at what's a rate on that first page, that can change over time.
Exactly.
And then a name that's not precisely right might show up on that page on one day when it wouldn't show up on it another day because of other things that have fallen off.
Or the agency changes its convention, and instead of outputting 20 names at a time, guess what? Our new default is it outputs 50 names at a time. That's just the default. You would laugh at it is luck. I mean, because it is going to be shifting by virtue of somebody satisfying a lien, taking it off, and now your list is going to change. But aren't we looking at lien perfection at the time you made the loan, or the time? Somebody should be.
But it's got to be replicable. You've got to be. Well, I don't know.
You look at the time when I make the loan, I should be printing off this, this sheet, show these are the 20, just to show that this is what appeared that day. That would be the appropriate thing. If I'm a subsequent searcher making a loan to someone based on what I'm seeing at the Secretary of State's website, that's prudent. That's what they should be doing. But I think it is a little bit random of whether you're going to be on that list one day and not. But
so you started by saying that the whole scheme depended on the filer. You put the onus on the filer to perfect its lien. And now your argument is, it's just luck, whether it's perfected or not.
No. The onus is always on that never changes. I would say for an erroneous, I think Justice Kennedy's question was, if you have an erroneous financing statement, it may or may not appear on that list of 20, depending on the day. And I agree with him that can happen, but that to me becomes evidentiary about whether or not it was perfected on the date in question. That's evidentiary. That doesn't mean that you don't enforce this.
There's not much logic in the search logic like that.
It's not perfect, but it does. If you follow it, your lien is perfected. The safe harbor, you prove that at some given point in time it was on the list. You're entitled to the safe harbor. If you file something erroneous, you run the risk that it's not on that top 20. You also run the list that some new financing statements get in ahead of you, push you off that list. But who should bear that risk?
Yeah, I don't know why you're defending it. I mean, this is a rare opportunity for us to do something to make the academic commentariat happy, to actually make the law more rational.
Is that the role of the judiciary? Is my question. Isn't that the legislature? And we're looking at the facts of this case. They didn't do it, and it didn't appear on the top 20. It appeared before it, and it's in the facts of this case. There was no lien perfection. You can criticize the safe harbor or not, but
I don't think anybody's asked a question disagrees with that. Now, we may be persuaded otherwise when the opposing counsel speaks, but I don't think any of these questions have been unfriendly to your ultimate position.
No, I like the amicus brief because of the analysis there, but I think they're going off target because you circle back.
All right, you're in your rebuttal.
Okay.
You can keep going if you want to.
No, sir. Thank you.
All right. Counsel.
Good morning. May it please the court. My name is Ezra Scrivenage, and I represent the appellee Live Oak Banking. The court's very aware of the background of this case. It's very obvious. Just some main points. My client provided 2 loans totaling $5 million, and it was secured by 19 entities, one which is now the appellant in this case. All the loan documents, as was described by appellant's counsel, all listed 1944 Beach Boulevard with the word Boulevard abbreviated. And if the court reviews the attachments, there's even certifications from the borrower that's the correct name. With that said, I think it's important because I think it shows that all the parties agreed from the outset of this loan that that was the name of this entity.
Counsel, could you?
This is about the rights of third parties.
Yes, the third party, in a way, I understand that. It is weird in that the third party being the debtor in possession in the Chapter 11 is also the borrower.
I'm sorry, Justice Roseanne says.
It's just, could you kind of address what we've been talking about,
Yes.
about whether the safe harbor provision is even a workable excuse, so to speak, if there's no search logic employed by the department?
So I agree that Florida's search system is terrible. I think a lot of people that have discussed this, we understand it just isn't a good system. The assumption or opinion of amicus that there is no search logic at all is true as compared to other systems they're relating it to. With that being said, Florida is stuck with what we're stuck with at the moment. And for purposes of what we're here on today, it's up for this court to interpret this provision, the safe harbor provision, and I would also want to talk about another provision in the same statute, in a manner that reaches the result the statute's intended, but also reaches a result that's not absurd. And I think it's absurd the way this search system works. And the fact in this case is, when you type it in with the whole word Boulevard spelled out in the search system, it pops up the first entry on the next page, because it's all alphabetical. So it's a simple one-click either way, and it could easily pop up when you're dealing with an abbreviation.
Let's start with just 50311.
Yes.
And so that's the starting provision of the statute, and it says that a financing statement sufficiently provides the name of the debtor only if it provides the name that is stated to be the registered organization's name on the public organic record most recently filed with or enacted, and it goes on. But you would agree that that requirement was not met because of the abbreviation, correct? Everybody agrees with that?
Correct.
Okay.
Correct.
Okay.
I would agree with that. And then I would then just bring up the section that the safe harbor's in, which is 679-5061. And subsection 1 of that refers to substantial compliance and minor errors and omissions, which there is contemplated if the safe harbor, as we're talking about, is illusory.
And that provision is perplexing, because it starts off by saying that minor errors don't matter in determining whether it's seriously misleading. But then it very plainly says that if the financing statement fails to sufficiently provide the name of the debtor in accordance with 50311, then it is seriously misleading. And so we've already talked about that, and so even though it says minor differences don't matter, it takes you back and says that they actually do, in very plain language, correct?
They do.
Okay, so and then that takes you to the safe harbor provision to allow you some opportunity to have a filing statement that's valid, even if you didn't get the name absolutely correct, if there is a search logic.
Yes.
Okay.
That's exactly. It all boils down to that provision is based upon a real search system with search logic, which Florida doesn't have. And I think since it's illusory, that the safe harbor in subsection 3 can't apply to Florida, right? Because we don't have it. So what do we have? We have subsection 1. I think this court in the past, in other issues, when it comes to notice, it's substantial compliance. Here, there was definitely substantial compliance when you look at the underlying facts of this case. And if you also look at the two cases that both the Middle District Bankruptcy Court, the district court sitting its appellate capacity, followed.
Counsel, I mean, if subsection 3 isn't operative because we don't have the standard search logic, you're not just thrown back on subsection 1. You're thrown back on subsection 2, which says financing statement that fails sufficiently to provide the name of the debtor in accordance with that, and another section we know about, is seriously misleading. And I don't see how, if you, following that, I mean, if subsection 3, if you have no refuge in subsection 3, it just seems like in these circumstances where you made the mistake, your client made the mistake of using the abbreviation, which is forbidden,
right? No
good, that under subsection 2 you lose.
And that is one of the interpretations that could be taken. And what we're proposing is that's absurd. It would be very unreasonable, the result, in Florida especially, because, you're dealing with a system that the UCC provision didn't envision when it was written. It was just adopted here in Florida blindly without any sort of view of what our system is. And it could change tomorrow, and all of a sudden we're perfected, and everything changes. But it's not that way. So really the relief we're asking from this court is to interpret this statute in a manner that's going to be reasonable in the facts of this case and fair to all the parties.
Well, I don't understand what's unreasonable reasonable about requiring that the creditor use the correct name of the debtor. I mean, that is a very simple, crystal clear requirement. And there are resources. I mean, you can go on the website at the Secretary of State's office and you can look it up, right?
Agreed.
And apparently somebody just didn't do that. They decided they would, I don't know, I mean, it's hard to understand dealing with millions of dollars in money, but mistakes happen.
I'm sorry, Keith. Are you making a reliance argument on the certifications that they delivered?
Well, it's a good point you brought up. So those issues were never addressed by the lower courts at all. But those are asserted defenses. There is a waiver estoppel reliance issue upon assertions. Now, I don't know if the court wants to go into that because I don't know if that's before the court. It's more of interpreting the statute, but I think eventually if we get back down on the other courts, ultimately the court would have to look at that component as well. But yes, that's a good point. So, I'm just asking the court basically, given the reliance, I guess, and the way our system works, there really is no workaround. There really is no safe harbor unless the court follows the court's opinions, the lower court's opinions, the middle district and the southern. And I understand that southern district opinion, the decision, the holding doesn't help me, but the reasoning behind it and how they approve of the middle district helps our client. So let me see if I have any other points, if the court doesn't have any other questions for me. I did want to point out, but again, this applies if we're looking at the safe harbor, but they talk a lot about the revisions did away with a reasonable search requirement. It did. I agree with that. You put in the right name, but there's a two-step process when you're searching for UCC financing statements. You got your search, and then you got your actual review of the documents. And I don't believe the revision did away with the fact that a searcher's got to use some sort of reasonable common sense in reviewing results, especially when you're only getting 20, and you're dealing with a loan that has 19 entities that secure it. So that's going to be 19 right there just on one loan times 2. So I think at some point the button's got to be pushed. Forward or backwards, how many times, no one knows. And I don't know if, I'm sure a lot of people care, just nobody knows. So, I would propose that, yeah, they did away with the reasonable search, but you still have to, there still is that reasonable examination step that's got to be taken. And I think that changes a lot. I talked about the cases. I really have nothing further. We discussed the amicus and the 800-pound gorilla in the room they pointed out, which is the fact our search system has no search logic in Florida. And with that being said, I have no further to present at this time.
Right. Thank you. Rebuttal.
Thank you, Your Honor. As Justice Lawson pointed out, the statute 679-50613 doesn't require a search logic. And we can't just ignore that specific wording, take it out of the statute. And I think with amicus and Live Oak and some of the questioning here today suggests, well, should there be one? Maybe there should. It's just not required under this statute presently. And that's what we need to come back to. And again, we're implementing. I don't have the qualms with the system that others might. I think it works fine. We rely on it when we make loans, when we do our searches. I'm a Chapter 11 specialist. When we're trying to determine what liens are out there, we look at that. And to your question earlier. there are 18 other debtors with collateral pledged to them. We, as a debtor in possession, that we are basically fiduciaries for the unsecured creditors and such. So this reliance issues and all that, that's way beyond what's here before the court. But just so you know that this is customary for a debtor to have these rights to fulfill his fiduciary duties to others.
But the point here is that they're not just reliance interest between the parties in terms of representations that were made, but this is about the reliance interest of third parties.
Correct. And there just has to be this level of certainty, which I think exists if you follow the statute. And it wasn't followed in this instance, no matter who's at fault, but the one person who could have checked the Secretary of State's records, got the correct name, and put it on the financing statement, didn't do it right. And it's unfortunate, but we balanced the risk. Searchers who input the wrong name can take it on the chin too. And so it's a question of this balance, the statutory scheme, the Uniform Law Commissioners, they've thought it out. We adopted it in Florida. It works. Maybe it's for the legislature to decide if they want to define add as a search logic. But I'm not real good with administrative law issues. But we have adopted a search logic, imperfect as some may believe. So thank you.
All right. We thank you both for your arguments in this case today. And the court will now take a recess of about 10 minutes before we take up the final case on the docket.
All right. before the current session. Please be seated.
The court will now take up the case of Coates versus R.J. Reynolds Tobacco Company. Counsel?
Good morning, Mr. Chief Justice, and may it please the court. I'm John Mills on behalf of the petitioner, Brenda Coates. 5 years ago, this court unanimously upheld a $30 million punitive damage award when this defendant's misconduct killed James Shove. The district court in this case, however, rejected half that amount.
What were the compensatory damages in that case, Mr. Mills?
In that case, they were $10.5 million, and that's the reason that the district court made its ruling. It found that it's not the actual dollar amount that is excessive here. It's the mathematical relationship between the punitive to compensatory award. It was 3-to-1 in Shove. Here, it's either 50-to-1 or 100-to-1, depending on whether you apply the ratio before or after comparative fault.
While you're on that, what were the claims on which liability was found in Shove?
The conduct was exactly the same as here.
What were the claims on which liability was found?
Sure. There was a claim in Shove for fraud because Ms. Shove proved reliance. We did not prove reliance on a false statement, so we do not have a fraud claim here. This is purely strict liability. But the defense conduct is exactly the same. The only difference is whether we proved reliance, and the only impact of that is whether there's a comparative fault reduction. The certified question doesn't address that at all. It presumes it's the same conduct. And the certified question, and nobody's asked to expand the certified question. We had jurisdiction briefs. They said keep it to the certified question. And that asks what is the maximum permissible amount, or whether the maximum permissible amount of punitive damages depends at the end of the day on the amount, the dollar amount of compensatory awards. This question is limited to wrongful death actions with modest compensatory awards, and in situations like its cigarette cases where we already have other awards that have been sustained for the same conduct and similar injuries. The court should answer the question in the negative because the applicable version of the Florida statute that governs the mathematical dollar-to-dollar ratio provides there's no ratio cap in this case under these facts. And under both the other applicable Florida statute for reviewing punitive damages and the Due Process Clause of the 14th Amendment, this award is not excessive compared to the injury that was inflicted, which is the death of a human being. That is the most serious injury that can be inflicted upon a person. So the applicable Florida statute that governs the dollar-to-dollar ratio is Section 768.73. And that was amended in 1999, as this court held in Sheffield recently. In a wrongful death action, it depends on when the smoker died. Our smoker died in 1998, so we're in the pre-99 version. That version provides for a presumptive cap, and it's a dollars-to-dollars cap of 3-to-1, and we exceed that cap. But the presumption does not apply if we prove by clear and convincing evidence that the award is supported by the evidence in this case. The trial court and the district court agreed we satisfied that. That was satisfied in many other cases that have all been approved, and that's not been challenged. So we don't have an issue under 768.73. I would note, however, that going forward, in any case where somebody died after 1999, that's going to apply. And so that statute doesn't apply here, but the amended statute would limit it. It has the same exception for the 3 times cap, and it gets you to a 4 times cap. But even then, it's not a pure dollar-to-dollar ratio because it's the greater of 4 times or $2 million. So if that applied here, we'd still be way over 4 times. We'd just be capped at $2 million. So that's what's going to apply in most cases going forward. We still have some Ingle cases with pre-99 deaths. This is a non-Ingle case. But most cases are going to be subject to that.
Counsel, isn't at the end of the day, though, when you read all these cases, it seems like there's a core concept that there has to be a reasonable relationship between the punitive damages and the injury that was found as manifest in the compensatory damages. And that courts, whether they talk about, everyone acknowledges that in the absence of a statute that creates a hard cap, that there isn't, a hard cap that judges could make up. But, the theme, the sort of recurring theme is that 1-to-1 is, can be acceptable and sometimes required. 2-to-1, 3-to-1, 4-to-1, you start getting on the high side. I mean, there's just nothing that I've seen that would suggest that when you're talking about 100-to-1 or 50-to-1, that you're even within the ballpark of anything that could be considered acceptable.
Where I would respectfully say you've made a mistake, Your Honor, is where you say the law requires comparing to the harm as measured by the damages. And there's two sources of law here, one state and one federal, and our position is both do not tie it to the amount of damages. They tie it to the injury suffered. The amount of damages is a component of the injury suffered, but it's not the end.
Well, but I think that, I'm sorry to interrupt you, but it seems like one of the challenges in this area, obviously, as you do a great job of pointing out in your briefs, is the difficulty of sort of, measuring some of these intangibles and whatever. And it seems like there is this kind of anchoring sense with the damages that, that does kind of ground everything and that sort of sets some parameters for then within that how all these other variables might come into play. And the amount of damages that are compensatory damages that are awarded is just an inescapable sort of kind of, center point for that.
Well, it's a component, but let me get to the specific tests. And our argument is largely the same under the state test, which would be in 768.745D, and the second guidepost of the Due Process Clause. Our argument is largely the same. Before I delve right into that, there is one important difference. The standard of review under state law is abuse of discretion. Under the Constitution, it's de novo. So the question is whether under state law, under the state statute, whether the trial court abused its discretion in finding death is a big injury and this is not excessive compared to that. Now, that is moot when we get to the federal because it's de novo, and that just doesn't matter what the district court said or the trial court. It's what you think. But it's still important in that whoever loses here may seek review in the Supreme Court of Florida. So I think it is important to clarify at the end of the day, is this a ruling based on state law or federal law? But starting with state law, the 768, the factor that we're talking about here is, quote, the relation of the amount of damages proved, which is what you're talking about, Justice Muniz, and the injury suffered. The statutory language makes clear we're looking at one relationship, not two relationships like they suggest in the answer brief. It's the relationship between the amount of punitive damages and two things. The compensatory award, that's the dollars, and the injury. Here, the injury is death. The only reason dollars don't sufficiently capture the value of a death is because this is a wrongful death case. And Florida has made the decision that you can't recover compensatory damages for the value of the death. You don't get that. So we don't even get money for that. But that's the injury that this caused. And it's the ultimate injury.
I think the legislature also said there's no punitive damages for wrongful death, but we can take up that issue.
Well, that's certainly not an issue in this case.
Yeah.
I haven't seen that preserved yet, but certainly that's not an issue in this case. In this case, the question is whether when the legislature says we compare to the amount of damages proved in the injury suffered, we ignore the injury suffered and we only compare it to the damages proved. That defies the plain language of the statute. We must look at the death. I think the best case to talk about this comes from another state that has a fair amount of tobacco litigation. It's Oregon. In the Schwartz case, the Oregon Court of Appeals upheld a $25 million punitive award that was 148 times far greater than the compensatory award. And it rested on exactly this logic that I'm telling you. And Oregon is just like Florida. The damage award does not reflect the monetary value of the death. The jury doesn't get to monetize that death. But in punitive damages, in determining if it's does this fit the crime, is this too much given the harm caused here, we don't need to look at damages. Economic, your paint job isn't good, your insurance claim isn't processed, somebody's defrauded you on a financial transaction, well then the economic damages may be the only real measure that we can apply. Not so here. Wrongful death, this is about the sanctity of life.
Well, then,
this is a jury.
I understand where you're going, but I wonder how much this argument really helps you, given that there is then no limiting principle. We could, if the punitive damages award here were $16 billion, am I right that you'd be making the same argument?
No, I think there is a limiting principle.
Okay, so
and I think
help me find it. Help me find it.
So, and I think this gets to the difference between abuse of discretion and de novo. Okay? For abuse of discretion, we look at the jury's determining the value of a life and comparing it. The trial court explicitly is doing so under the statute. And so, and then it's abuse of discretion review. Under the due process clause, you guys, it's the highest court, has de novo review. You don't have to care what anybody else says. It's what you feel. How much is too much for killing a human being? And I think these are great cases to answer that question because we have a long list of cases where we have awards. We have awards for living smokers, $10 million. You can get $10 million or more have been affirmed for a living smoker, just like Ms. Stuckey. If Ms. Stuckey...
You're saying, just I want to make sure I understand your argument. You're saying that then the appeals courts of this state should conduct some sort of proportionality review anytime there is an award in one of these cases to sort of de novo determine whether or not it's within the heartland of what's acceptable, not based on some multiple of compensatory damages, but the value of human life. Is that the judicial project you're asking the courts of this state to undertake?
I'm not asking you to do that. I believe the Supreme Court of the United States has commanded that courts do that in its interpretation of the due process clause. I think they've gotten it wrong, and I think that Justice Scalia and Thomas are correct, but yet that's where we are. And that is the law, and courts are supposed to apply de novo review to determine. And it's just one guidepost. For both the statute and the Constitution, if you disagree with everything I'm saying here and say, no, it's just dollars to dollars, we should still prevail. These aren't separate tests. These are, in both cases, they're factors to apply. For the guidepost, we were already told reprehensibility, which this court held, $30 million is justified based on reprehensibility. That's the most important one. And if you can have something that's the most important, that means the other two, any one of them, is not required. So any deficiencies, I think we fully meet the second guidepost. But even if because we have low damages here, we have a deficiency there, it should still be outweighed.
Could you address, and it kind of goes back to what Chief Justice Kennedy asked you about, how, in terms of the reprehensibility, how should we think about the fact that it was only the strict liability claim that you prevailed on? I mean, is it an inconsistent verdict situation, or because I mean, you said there was no reliance, but that's another way of saying there's no harm caused to this particular, at least to the decedent.
That's not what I'm trying to say. What I'm trying to say, and what is the case, is that we're talking about punishing conduct. And the conduct is exactly the same. We proved this isn't an Engle case, so we had to prove up strict liability. And this was actually an issue on appeal in the 5th DCA. Did we present enough evidence? So you can look and see what was the evidence that carried the day. And it's the exact same evidence you put on in a fraud case. That's because a defective design theory is based on consumer expectations. Does a consumer reasonably expect this to be a safe product? And we put on evidence that they do, reasonable consumers. Maybe we didn't have individual reliance here. Maybe she learned at some point, or more likely, we just couldn't prove it because she's dead, what she relied on. But the reason they're strictly liable is because they manipulated consumer expectations with all their marketing.
But reprehensibility implies, obviously, sort of a moral component to it, and strict liability is neutral on that. I mean, it's an efficiency.
It does, and so the strict liability doesn't get you punitive damages. That's what this court held in Sofer. Once you prove that strict liability, you don't have to prove any reprehensibility for that. But to get punitive damages, you do. By clear and convincing evidence, you have to show that it wasn't just strict liability.
You're relying on the reprehensibility to sort of make up for the fact that in terms of the dollar comparison, that it's so disproportionate?
If you think the dollar comparison and not the injury comparison is correct, then yes, I am. And my point is it's the same conduct. And more broadly, even if you disagree with me on that, that issue is not before the court. So this is a certified question.
Is the logical, though, so if, and this kind of gets to what Justice Coriel was saying, I mean, are you saying then that where the injury is death, that essentially because I mean, you could always, there's no amount of money that you could say makes up for that. So are you saying that where that's the injury, that essentially the amount sort of goes out the window?
Not at all. No, I think that you, de novo, should say what the amount is, because the conduct's the same in all these, the death is the same. So let's just say, let's not play.
So four of us are supposed to sort of platonically decide how much a death is worth?
That's what the Supreme Court of the United States has given you. I don't understand why they did that. I don't think they should have, but they did. And so, yes. And you've already said $30 million is not excessive. And so I think that's the floor. And we're under $30 million. I think you should say $100 million.
Mr. Mills, what does it matter that the trial lawyer or your client asked for $10 million, but yet the jury came back with 16?
Right. It doesn't matter at all. There's express findings of no passion or prejudice. In Schoaf, the jury also awarded more in punitive damages. Actually, in Schoaf, the plaintiff's lawyer begged them, please don't award more than $25 million, because that had already been approved. They awarded $30 million, and this court said that doesn't matter because it is for the jury. And as long as there's no passion or prejudice, the plaintiff's lawyers, the name of the game is to avoid the appellate courts in these cases, get these cases tried. So we don't push the boundaries. Anytime closing argument, boundaries, any people who've been pushing the boundaries there, they're retrying their cases again and again. The name of the game is safety. So we don't ask for more than we think is super safe. And we thought, well, this is a big ratio. Monetarily, let's ask for less. But this jury decided the sanctity of a life is worth at least $16 million.
But why do we, I mean, don't you think, though, that the fact that they rejected the claims, any of the claims that had anything to do with any sort of culpability, even negligence, and then they come back with this $16 million award, I mean, isn't that kind of indicative of passion or prejudice in the sense of sort of irrationality or just desiring to punish conduct that wasn't even culpable?
First off, that issue's not before the court because that's not, the certified question assumes that's no problem. Secondly, I would say it's very reasonable for a jury or for a state to say that the sanctity of all life is the same. And if you kill a person, you should be punished the same amount, whether that person happened to be Elon Musk, who had billions of dollars in lost earnings, or somebody who died with no economic damages, and they drug this out, and their spouse died by the time they got to trial, and their children died, and so there's no damages at all. You could have the death. We have them in these cases. There's no compensatory damages at all. This court has held you can award punitive damages when there's no compensatory damages. And where here we don't get any, and you got no award at all, certainly a $16 million award, a $30 million award would be appropriate. And on the flip side, for somebody who has a $100 billion economic loss claim, I would not say even a 1-to-1 ratio would be appropriate. There should be no more punishment for killing that person than for killing anybody else. So maybe $30 million is where you peg it to. I would suggest $100 million. That's about $10 million is a fairly common compensatory award, 10-to-1. This is the most reprehensible conduct this court's seen. So it needs to set the bar high. We think it should be $100 million. This court has already said $30 million isn't too much. And I think, again, it's the sanctity of human life. The judgment, when we're talking about the Constitution, it's does the Constitution prohibit a state from saying every life is valuable. And if you take somebody's life, the punishment is going to be the same. The maximum punishment is going to be the same, whether they left a widow behind or children behind, had a lost earnings claim, or had nothing. And that's not unreasonable. It's not unreasonable to say if you kill a person, this is the punishment you should expect. And you should not. That's what's so, to me, unreasonable about the position here. If we've got this dollar-to-dollar thing, then what we're saying is that by R.J. Reynolds not killing her earlier or not giving her lung cancer, if she got that lung cancer earlier and had it for years, and she just didn't die, and she got to court, she'd get $10 million for her own suffering.
I've let you use all your rebuttal time almost, but I'm going to give you some anyway. So you'll have 4 minutes for rebuttal.
Thank you. Thank you. I would just close that in saying that you need to have punishment. They should not benefit from killing somebody. The award, if they hadn't killed her, would have been in the range of $10 million. And the whole idea that by killing her and leaving no survivors, they don't get punished as much, that's obscene.
All right. 3.5 minutes for rebuttal.
Thank you.
Mr. Chief Justice, may it please the court. Brian Lee on behalf of R.J. Reynolds Tobacco Company. With me at council table is Andrew Bentz. As the court has said, the $16 million punitive award in this case dwarfs the compensatory award by a ratio of 107 to 1. That is unprecedented in Florida. More to the point, it renders the award excessive as a matter of both Florida and federal law. This is not a novel issue. This court held in Engle and then again in Sheff that there must be a reasonable relation between the punitive and compensatory awards. The U.S. Supreme Court has held the same thing in a string of cases.
Could you address the textual argument that the other counsel made about the damages being distinct from the injury suffered?
Right. So Section 768.74 lists 5 criteria. There's a prerequisite part of that, which is that it uses the word criteria. Unlike in counsel's brief, it does not say factors. Criteria is a standard, according to the dictionary, a standard for measuring adequacy. The fact that we have multiple means each one can make a difference. These are tests that must be met. I think a great example is actually in the dictionary when it talks about the criteria of an adequate diet. Nobody would say, he eats no vegetables, but he has made up for it in protein. No, you would need both. So they have to be met. And the one that this case has turned upon in the district court's estimation is 768.745D. And it requires a reasonable relation to the amount of damages proved and the injury suffered. Contrary to plaintiff's suggestion, our position does not leave the phrase "and the injury suffered" of no account. What that means, and remember, this is a general remitter statute. It applies to punitive damages and compensatory damages alike. And it means in determining how fine a tooth comb to go into evaluating the amount of damages proved, you take into account the sort of injury at issue. It reflects the traditional rule that we largely defer to juries for pain and suffering or intangible damages. We're a little stricter with economic damages. It just has no role to play in this case because we are accepting the compensatory award stands unchallenged by plaintiff and defendants. So we have already got a monetization of the compensatory award.
So you're saying the injury suffered is referring to de minimis harms, or help me understand. I'm not sure I hear really the answer at the end there.
Okay, so no, it's not referring to de minimis harms. The rule that has allowed substantial punitive damages for nominal awards under state law pre-exists the statute. It's probably inconsistent with it, but maybe it's grandfathered in. But what I'm saying is that imagine you have a compensatory award. You have a remittitor or an additor argument based on it. That is saying take into account the nature of the injury. If it's economic, we look at the medical bills. We don't give the jury leeway. There's got to be proof. But when it's pain and suffering, it's telling you consider the nature of that injury. We know that's largely in the jury's wheelhouse, and so we don't get into fly-specking them.
Okay, so you think it's a direction to look at the nature of pain and suffering as opposed to, say, a violation of a product liability case. That's your election. Your reading of the statute is when we look at the nature of the injury suffered, separate and apart from the compensatory damages, you want us to look at the victim's pain and suffering and not, for example, the consequences of a negligently designed product.
So I think that because...
I'm not sure how that helps you.
Well, no, that's not what I mean. I just mean that the injury suffered tells you how closely to evaluate the other part of the statute, because we're reading it holistically, the amount of damages proved. It just happens not to play a role here where we have an unchallenged compensatory award doing the work. And the court should reject plaintiff's alternative reading for 3 reasons. So plaintiff's reading has been it's 2 objects, And the injury suffered, assume you don't have a reasonable relationship to the amount of damages proved, which the question presented that plaintiff has urged here presupposes is the case. It actually asserts that it's excessive as compared to the compensatory award. That a plaintiff can paper over that with a reasonable relation to the injury suffered. That argument fails for three reasons. One, it renders the phrase "the damages proved" superfluous. Damages proved are always going to be coextensive with or a subset of the injury suffered if you're viewing the injury suffered in some philosophical sense. If you've proved the damages, you must have suffered the injury. And so plaintiff's just reading the damages proved right out of the statute. Second, assume it is two objects, like plaintiff says. The statute uses the word "and." It doesn't say you can have a reasonable relation to the amount of damages proved or the injury suffered. It says you have to have both. So even if plaintiff's right that it's two separate objects, they both have to be met. And then third, plaintiff's reading would violate a well-established principle articulated by the Supreme Court that we presume that legislatures do not hide elephants in mouse holes. And I again want to stress, this statute, it is a general remittitor statute. It applies to compensatory and punitive awards alike. And statutes aren't chameleons. So whatever ruling and interpretation this court gives here is going to apply when you have a challenge to compensatory award too. And so on plaintiff's reading, a court can come in, you have a jury, evidence supports their award, they've obeyed the legislature's commands on the substantive law, and the court can say, well, I'm going to grant additor, or I'm going to deny remittitor, because I don't think the legislature has adequately accounted for the injury in sort of a platonic judgment sense. And that cannot be right. That would let courts, imagine challenges again to compensatory awards, run roughshod over things like proximate cause that limit liability. We know the injury happened, we just don't think it's a legal cause. It could run roughshod over things like statutes of limitations, where part of the damage or the injury has been cut off by passage of time. Or, in cases like this one, the legislature has told us how they're valuing this harm. They're valuing it on the effects on the living, and a court can say, I just don't disagree, I don't agree with that, I don't think the legislature's done enough, so I'm going to trump it. That is a sweeping judicial power. There is no way that the legislature intended to bury that in 4 words buried in a provision in the middle of the remittitor statute. And that's yet another reason to reject plaintiff's reading. And so we're right back to talking about a reasonable relation requirement, exactly as this court said in Sheff, exactly as this court said in Engel. That was as a matter of state law. Plaintiff's only response to those precedents in and of themselves has been to say, no challenge to them, not trying to meet Poole's standard of clearly erroneous, but it has been to say, well, Engel was mostly about about federal law, excuse me. That's incorrect for 3 reasons, or it doesn't get the job done for 3 reasons. One, it wholly ignores Sheff. Relevant part of Sheff is in a separate section of the opinion, denominated state law, cites the state remittitor statute, so it's clearly a state law holding. Ignores the language of Engel. The relevant passage in Engel says, it talks about what state law requires. It cites this court's then existing precedents, which were from 1979 to the date of Engel, wherein the court said, we're going to abandon the traditional law rule requiring a reasonable relation. It starts with Lassiter, extends to Engel. And then it says, we now hold consistent with due process. Not a direct application of due process. Consistent with due process, we're changing state law to account for it. So Engel is a state law holding. And then third, even if that were wrong, and even if you were to put aside Sheff, still, Engel, plaintiff acknowledges, squarely held, you have to have a reasonable relation between punitive and compensatory damages. So that just means...
I'm sorry to interrupt you, but in those 3 paragraphs in Engel, or 4, whatever it was, it sort of like shape shifts from talking of... So, but even if it is state law, it's state constitutional law, right? They weren't analyzing the text of the...
So they certainly weren't analyzing the text of the remitter statute. That shows up in Sheff. But it gets the job done even if the court wants to go.
Is there a difference between the remitter standard on the reasonable relationship with the damages and the due process standard? I mean, are we basically just, I know that the abuse of discretion versus de novo, but I mean, are they the same thing?
So that argument, short answer is I don't think they necessarily are. And the reason is that the Supreme Court has given us, U.S. Supreme Court, has given us other guideposts and factors to consider. And so I think there could be a delta between the 2 in specific cases. I would say 2 things about that. 107 to 1 is unreasonable on any estimation. And then even beyond that, if there was a delta, it's not presented here because the DCA left it to the trial court to figure out what the appropriate ratio was on remand, and did that with plaintiff's express permission. If you watch the YouTube video of the argument, when asked, plaintiff says, yes, you can leave this to the trial court. And so the court doesn't need to draw the line here beyond saying this award is unreasonable, and we've never pressed for a difference here. You know, we have said consistently that it's 4-to-1 or in the range of 6-to-1 to 8-to-1 if the court were going to get into that, which again, given plaintiff's position in the lower court, would be effectively sandbagging the 5th DCA for not identifying the line itself. And so we'd urge the court not to do that, but 4-to-1 or 6-to-1 to 8-to-1 would be the proper ratio in this case based on our positions, even if there could in theory be a delta. I also heard section 768.73 come up. I'm a little bit hesitant to address it. On page 5 of plaintiff's reply brief, plaintiff disclaims the idea that it displaces somehow 768.74, but in abundance of caution, because it's such a central feature of their opening brief, I will say that that's not true. 768.73, the old version, is a presumptive 3-to-1 cap, and for reasons both textual and structural, it doesn't displace the reasonable relationship requirement. Those two statutes were passed together in 1986. They're in pari materia, and they both use a key phrase. The textual point is they both talk about, quote, the facts and circumstances presented to the trier of fact. 768.74, the general remitter statute, uses that phrase to introduce the concept of remitter and then to introduce the 5 criteria, the 5 must-be-met tests that govern remitter. 768.73 says when you're deciding whether an award permissibly exceeds the 3-to-1 cap, and by how much, you look to the facts and circumstances presented to the trier of fact. And so it's encompassing those criteria. I'd add that that only makes sense structurally. There is no way that the legislature thought that the ratio between punitive and compensatory damages was so important to set a presumptive cap, that the criteria in general were so important to govern remitter and additor, and then all of them just fall away when you have an award that exceeds 3-to-1 and therefore presumably is most in need of some scrutiny. And so 768.73 cannot displace section 768.74. Frankly, that resolves the case. Plaintiff has not tried to argue that the award in this case of 107-to-1 is reasonable if there is a reasonable relation requirement. Again, has urged the court to review a certified question that presupposes it's not, and couldn't make the case even if it was tried. The court adheres to principles of state law primacy and, of course, constitutional avoidance, counsel against going any further. But if the court were to go further, the U.S. Supreme Court's precedents likewise would require affirmance. The court has given us the 3 constitutional factors. It has told us how to apply the second factor. Time and again, it has looked to the ratio between punitive and compensatory damages. It has done so to reverse awards in Campbell and Gore. It has told us in Exxon that it is, quote, the ratio between punitive and compensatory damages are, quote, a central feature of our due process analysis. And it has given us guidelines ratios that monetize how to do that. I heard some of them mentioned earlier. 4-to-1 has been often marked as the outer bounds by the Supreme Court, and it has told us that 9-to-1 is the outermost limit in, quote, all but the most exceptional of cases. And so this award ratio is more than 12 times larger than that. That confirms the excessiveness. Plaintiff's argument has been to latch on to the language actual potential harm and to look to other cases, compensatory awards in other cases, or hypothetical cases. Supreme Court has squarely said not to do that. Philip Morris v. Williams said you cannot base punitive damages on harms to others, and it has said you cannot base punitive damages on hypothetical claims, and that is State Farm v. Campbell. I would add that that is the only way to be consistent with the court's case law. There is no reason the court would have consistently looked to ratios if courts could just inevitably jump to their own sense of what an injury should be.
Can I take you back to the remitter statute?
Absolutely, Your Honor.
So Section D, just a couple of questions where it mentions the injury suffered. Do you agree with your opposing counsel that it's the death that is the injury?
I think there's 2 ways that looking at it, but they dovetail back to the same thing. One way of looking at it is that it's not the death. The legislature has chosen to compensate for the survivors, which is in keeping with the traditional rule that didn't allow any recovery in the event of death at all. The second way of looking at it is that that is how they're compensating the death. They have decided to value a death according to the effect on those still living. And my friend has suggested that this shouldn't be circumstance specific, but the fact is the remitted statute makes it circumstance specific. It is not talking about somebody else's injury or the amount of damages proved by somebody else. It is latching it on to this case as the legislature has defined the injury and harm. And so you do wind up in this case dovetailing right back to the $150,000 compensatory damages award. To speak to my friend's last point in the briefs about trying to make the reasonable relationship requirement fall away under the federal analysis, that fundamentally misunderstands how the guideposts work. They are not a 2 out of 3 contest. It's not tic-tac-toe. It's instead interrelating factors that play off of each other. The Supreme Court has made that clear because it has said in Campbell that the second factor must be met in every case, and that is not in any way inconsistent with the idea that reprehensibility should be driving the bus. That quote, the idea that reprehensibility is the most important factor, shows up in the same opinion. So it's not like the Supreme Court, they don't say inconsistent things in an opinion as a matter of course. And so what that means is reprehensibility tells us where within the guideposts an award can fall, the guidelines ratios, whether an award can exceed the ratios, and if so, by how much. But it does not allow us to drop the reasonable relationship requirement out of the case altogether. So it tells us what counts as a reasonable relationship with that anchoring function, but it doesn't do away with it. I do want to dovetail back. We did preserve Martin. That is in our brief. We have preserved. If the court is going to be inclined to rely on Martin for anything, it should just overrule it. That case was inconsistent with the statutory text in holding that punitive damages are available in a wrongful death case. And more to the broader point, there's a suggestion that we said keep it to the certified question and that the court shouldn't consider the nature of the claims. We preserved that argument at every level. We weren't required to do anything with it at the jurisdictional briefing stage. This court's rule says that you only need to raise affirmative and independent issues, and to the extent these are factors playing off each other, the issue is not only independent, but it's not affirmative. We're relying on it to defend the judgment of the court below, and so the court absolutely should consider that this is a strict liability case in deciding what it thinks was reasonable if it decides to get into the question of what is reasonable. Again, I think the court here, given the way the case was litigated by plaintiff below in the concessions, should stop with saying that the 107-to-1 ratio in this case is reasonable. But I just didn't want that to get lost in the shuffle. I'm happy to answer any questions from the court. Otherwise, I will yield the podium. Thank you.
Thank you, counsel. Rebuttal.
These cases are the most exceptional cases. Corporations to make billions of dollars engaged in intentional design and marketing decisions, knowing it would kill hundreds of millions of people. This is where you set the bar. Engel and Schoaf did not involve this issue. There were not modest damage awards involved in that case, so anything to suggest it's just based on dollars was pure dicta there. And in fact, in Schoaf, this court said, this is talking about the Supreme Court's second guidepost, which is the disparity between the actual or potential harm suffered by the plaintiff and punitive damage award. There's no ratio in that. It's not a ratio of dollars. It's just comparing the award to the actual or potential harm. This court unanimously said in Schoaf, to evaluate the relationship between damages and harm, the punitive damage award is compared to the actual or potential harm suffered, not the actual harm alone. So you do look at potential harm, and you don't look just to the dollar award. What will the rule be? I've still not heard an answer. What will the rule be for we don't have a modest award, we have a no award? You don't have any damages proven. You've killed somebody, there's no economic damages, there's no survivors left, so it's just nominal damages are zero. Does the Constitution and this statute mean they don't get punitive damages at all? That can't be the case. The legislature has said there's no ratio whatsoever if it's small enough. Even under the new statute, it's capped at $2 million. If you have $1 of damages, that's a 2 million to 1 ratio. In TXO, the U.S. Supreme Court approved a 528 to 1 ratio because the conduct and the injury were so serious, but the damage award was so low. Under this 1-to-1, if we just look at the dollar award, let's look at the other side. Elon Musk, whoever, some rich person dies and has $1 billion compensatory claim. They're going to say they get punished $1 billion for that? I would say that's excessive, ironically, because every human life should be treated the same. When we punish somebody for killing a human being, it ought not depend on whether that was a great human being who left a bunch of people behind or a bunch of money or somebody who didn't. That's irrational. The statute doesn't require it. The Constitution doesn't require it. Punitive damages are not for compensating. They're for punishing. The compensatory damages are where the legislature makes the judgment of what get compensated. Punitive damages are where the jury makes the determination, subject to reasonableness review, of how much punishment is warranted for the conduct. And the conduct is exactly the same. There's no difference. There's no difference between the conduct in this case and the conduct in Schoaf. The only difference is that we could not show that Ms. Schoaf didn't realize. She didn't learn, oh, I should quit smoking in time to avoid it. We don't know because she's dead. Nobody can ask her why she kept smoking. But we do know she got lung cancer and died because she smoked a product for which they're liable because they intentionally manipulated consumer expectations to think it's safe. So they're responsible for that.
That's not part of the strict liability. That's not an element of strict liability.
Consumer expectations, it sure is.
No, but the intentional manipulation.
No, correct. That's to get punitive damages. Right. We didn't have to. You can have lots of strict liability cases. You don't even seek punitive damages. You have to show way more than just liability. That's what this court held in Sofer, though, that you can, and as long as you prove by clear and convincing evidence intentional, grossly negligent conduct, knowing it's going to kill a whole bunch of people, that's when you get punitive damages. So you've satisfied you've got a claim, and now we look at what is the conduct that gave liability. Yes, we didn't have to prove negligence even to get liability, but to get punitive damages, we had to show the same thing we showed in Schoaf, and we
Counsel,
did.
you need to wrap it up.
I think I've made my points. The sanctity of human life is what this is about. Can a jury, can a state determine that the punishment, the maximum punishment allowed for killing a human being should be the same regardless of the human being? Isn't that rational? Even if you don't agree with that, isn't that rational? Isn't that something the state could do when they say not just damages but the damage and the injury? Isn't that something rational a jury could say? Every life is worth the same when it comes to punishment.
Right.
Why would we say otherwise?
Thank you both for your arguments in this case.
All right.